Okay, you said your last name is pronounced Magoo?
Yes, ma'am.
And generally speaking, I appoint the public defender's office to represent at least at the arraignment stage, but I was informed that you didn't want to speak with the public defender, so are you intending to represent yourself for the arraignment?
I'm here to figure out what the charges are. What am I being charged with?
Danny Magoo.
Ready for preliminary examination, or at least to deal with his motions? Whatever we're doing.
Yeah, would the court be so kind as to make the self-representation inquiry? And
Yes.
Perhaps we could look at the motion first.
Mr. Magoo, you are here before the court. You're set today for a preliminary examination. You're here before the court on the charge of resisting and obstructing a police officer. That's a felony, punishable by up to 2 years incarceration, $2,000 fine plus court costs. You appear here unrepresented as you have in the past, and the court has given you the admonishment regarding self-representation. You're going to represent yourself.
And there it is. He's officially declared he's going pro se. For the unfamiliar, pro se means he's choosing to represent himself. And while that's a constitutional right, it's a dangerous game without training. Courts must ensure the defendant understands the stakes, and the judge does exactly that here. This isn't a traffic ticket. It's a felony. One mistake, one missed objection, or one misunderstood motion can tank your entire defense. Would you ever represent yourself on a felony
I did
charge?
not, but I don't think I properly served it on the prosecutor, so I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. So what do you want me to do with your case today?
Well, I a few things. I want my bond conditions lifted. I want a discovery. I don't know exactly what the procedures here is. You know that wrongly.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yikes. That awkward silence, that's the sound of reality setting in. The judge just called out the defendant's lack of preparation. What started as a seemingly organized approach quickly spirals into confusion, with bond condition complaints, unclear requests, and scattered legal references. Pro tip: if your courtroom plan includes phrases like, "I don't know either, Your Honor," it might be time to consult an attorney.
You don't want help?
No.
Okay. So I'm going to do this. I'm going to apprise you, if you wish to represent yourself, you're constitutionally entitled to do that. I will apprise you that you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration and $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
This is critical. When representing yourself, the court treats you exactly like a lawyer. That means no special treatment, no explanations, no hand-holding. You're expected to know evidentiary rules, courtroom procedures, and how to argue motions. The judge is making it crystal clear. And this warning isn't just formality. It's a safety net that the defendant is about to ignore.
Be represented by an attorney. The court will afford you that opportunity to be represented. You understand that?
That process is throughout the whole discovery and trial.
Pardon?
I can be assisted with if I can.
If you
later
request
charge.
an attorney represent you in this matter, that the court will at that point, if you cannot afford to hire one, the court will make sure that you have one. If you wish to get your own attorney, the court will afford you that opportunity to do that. You understand that?
I do.
So what do we wish to do today?
I would like to first file a request for suppression of this evidence until
Suppression of what evidence?
of body cams, squad footage.
On what basis would you be doing
Boom,
that?
he cites Miranda v. Arizona incorrectly. He claims his rights were violated, but here's the thing, Miranda only applies when someone is in custodial interrogation. Even then, failing to read Miranda rights doesn't automatically suppress all evidence. especially things like body cam footage or squad video. And remember, the defendant admits he hasn't even received discovery yet. Can you really suppress evidence you haven't seen?
You know, give too much legal advice. So I'm trying to take as much responsibility for this as I can.
Okay, well, I'm going to, at this point, deny that motion because there hasn't even been a request for discovery. If you don't get something, then you bring a motion for discovery.
Okay.
Next thing you want to do.
Discontinue all hearings until there's substantial evidence on file.
Okay, that doesn't happen that way. I don't know what discontinue all hearings
This
mean.
moment right here, he asks the court to discontinue all hearings until there's substantial evidence on file. The judge is baffled. Why? Because that's not how due process works. Evidence comes through discovery and motions, not by halting the system entirely. Question to our viewers: if you were the judge here, would you keep letting this play out or strongly recommend legal
Process
counsel?
if we're going to go at this rate.
What does the prosecution expect next in this case?
Pardon? What do you mean?
You're asking me for what I want out of this case and what I expect.
I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
That's not going to happen.
Okay, so
I mean,
what do I got to
going
do
home
to
is
get?
an option, but the charges aren't going anywhere.
I understand, and that's the end goal of where I want to be one day, acquitted of all charges.
Yeah, I don't mean to interrupt, but I am from the public defender's office. I'd be happy if the court wanted to pass us to talk with this gentleman.
He says he wants to represent himself, and if he wants to talk to you, then yeah, I mean, I know, Mr. Getty, and I appreciate it, but what do you want to do, sir?
I'm not sure what you're asking me. What am I
What
asking?
are my options, Your Honor? That's the line that perfectly illustrates the problem with self-representation. The court can't offer legal strategy. It's not the judge's job to guide you through your own case. And that's exactly why the judge keeps reiterating, he won't help. This isn't a customer support line. It's a felony courtroom. When you ask open-ended legal questions mid-hearing, you're setting yourself up for a procedural
These
mess.
crimes.
Okay, sir, it doesn't, you seem to want this process to work a way it doesn't.
Maybe that's the disadvantage of being pro se. Your Honor.
Yes, there are huge disadvantages because I think you know what you're doing, but you don't. It's become readily clear to me. You have no idea what you're doing.
Right.
And so I'm going to ask you, and it's going to cause some difficulty for you. So I'm going to ask you again, do you wish to be represented by an attorney?
I do not.
Okay.
This is where the wheels come off. The judge tells him straight, just because you string together legal words doesn't mean your argument makes sense. And here's the kicker. The judge suggests a competency evaluation. That's serious. If the court questions your ability to understand the proceedings, you could be ordered for psychological evaluation, which delays everything. This is courtroom reality at its rawest.
Sense. And if you think it does make sense, then maybe this court needs to send you for a competency. And I'm not saying that jokingly. This doesn't make any sense. I'll grant your adjournment. Next time you'll need to fill out a sheet to do it, but I'm not going to waste the time today to do it because
Thank you, Your Honor.
In your honor, for the record, I put the email address the defendant should contact for discovery on this post-it note, which I'm going to place here, and he can pick up. He's indicated he doesn't want to communicate with me about his case.
he doesn't want.
Oh, at
He
that
doesn't want to
moment.
communicate with me about his case earlier, so I'm not going to speak with him today about his case. So I've given him the post-it note to get discovery.
Oh yeah, that's a good way to get this going. All right, probable cause conference. Let me at least have some turkey before I have to deal with this again. December 5th. Court is clear, does believe that you do indeed understand the charges as well as the maximum penalties. There are certain dangers in representing yourself, and it can be fraught with some difficulty. However, I would indicate to you that you are absolutely constitutionally entitled to represent yourself if you so choose to do so. I will treat you no better, no worse than a licensed practicing attorney, but that also means that I will not show any favoritism. You are to also understand and know and operate by the Michigan Rules of Evidence and Michigan Rules of Criminal Procedure. If at any time during the course of these proceedings you decide that you wish to be represented by counsel, cannot afford to hire counsel, then an attorney will be provided to you. So that we don't get into a thing, I am going to assume, unless you say something different, that you understood everything that I just said. Hearing nothing different, what are we doing? Sir, do you wish to be represented by counsel? I guess I'll ask that.
I do not.
All right.
Thank you, Your Honor.
What are we doing?
I think defendant has a pending motion.
Yes. Go ahead with your motion, sir.
Still waiting, motion to compel the officers. I thought I'd be here today to speak with them on the record. It's what I've been requesting since my arraignment.
I know, but you requested a deposition. That wasn't going to happen. So what is it you're looking for the court to do?
Your Honor, I'd like to speak with the officers on the record. I've been requesting this since I'd like to.
So do you want to have your preliminary examination? Is that what you want to have?
Yes, Your Honor.
All right.
Sorry.
Is there a response from the people regarding that?
Your Honor, that is one part of the motion.
I know.
And so as to that part, people will be requesting an adjournment of the preliminary examination today as the officers are not here. But as to the other pieces of this, that there are many more things. I did file a written response, which I'm happy to rely on, unless the court has specific inquiries placed to make of that is not sufficiently flushed out.
All right. Sir, what about the other part to your motion?
Is that in regards to waiving my bond conditions? Which part are you referencing, sir?
It's your motion. You go ahead. I will rule on that part. What other part of your motion do you want the court to deal with?
To waive all bond conditions, leaving the state, and I'd like to get the officers on record. That's really what I've been wanting to do. I thought that's what I was here today. I was prepared to do, Your Honor.
Do you have all of the discovery?
I was just submitted an audio file this morning, Your Honor, from
Tech troubles strike. The defendant finally gets a piece of discovery, an audio file, but can't open it. According to the prosecutor, it's likely a Mac compatibility issue, not corruption. Discovery problems like this happen often, but here's the catch. When you're pro se, you're your own IT support, legal advisor, and strategist. That's a lot of hats to wear, especially under pressure.
They have a MacBook, and I know that those can have a little bit more of a difficult time with some of the audio files that come from my office, so that may be something that, I don't know that the file is corrupt. I think there's just an issue playing the audio.
Got it. And this is a audio of?
I believe it's the 911 call that brought the officers to the scene.
Now calling case number 25S00289.
Even now, deep into the hearing, the defendant doesn't seem to understand the charge against him. That's a huge red flag. The court is required to make sure a defendant comprehends what they're facing. And when someone repeatedly asks, who's the victim, or what is the charge again, it raises serious concerns about capacity, or at least comprehension. This is the moment the case pivots toward a competency review.
Not a surety of the state. I'm not a ward of the state.
Okay.
Can I ask what the charges are?
Yes, I am getting there. Please give me a moment. So, What we are here for today is an arraignment. The purpose of an arraignment is to inform you what you are being charged with and to make sure that you understand the charges. I am not going to be asking if you agree with the charges. I am not even going to be asking if you understand why you are being charged with them. The purpose is to make sure that you understand what the charges mean and that you understand what the potential maximum penalties are. So, what I have here is a misdemeanor complaint that charges that on or about or between the dates of February 15th, 2025 and June 23rd, 2025, you did maliciously use a service provided by a telecommunications service provider with the intent to terrorize, frighten, intimidate, threaten, harass, molest, annoy, or disturb the peace and quiet of an individual with whom you have a child in common, by using any vulgar, indecent, obscene, or offensive language, or suggesting any lewd or lascivious act in the course of a conversation or message through the use of a telecommunications service or device. This is otherwise known as malicious use of a telecommunications service. Do you understand what the charge means?
I do not understand that. I do not understand malicious use
Let
of a
me
telephone
rephrase.
service.
Do you comprehend that what I am saying is that you allegedly maliciously used a telecommunications service device that would generally be a cell phone? I suppose it could also be a computer or something else.
No, that
you
didn't
could
happen.
use. Okay. And again,
February,
as I
what were the
stated,
dates? What dates?
between February 15th and June 23rd.
Of this
of
year?
this year. Yes. Okay. Now, as I stated at the beginning, I'm not asking you if you agree with the charges. I'm not asking you if you understand why you are being charged with them. What I want to know, basically, is do you know what the words coming out of my mouth mean?
No.
Do you know what the words coming out of my mouth mean? And he says no. That's the point of no return. The judge can't move forward with arraignment if the defendant doesn't understand the language used to describe the charges. So let me ask you viewers, do you think this is a case of legal ignorance, a language barrier, or something deeper? Comment below with your take. Is he overwhelmed, confused, or deliberately
A
stalling?
competency evaluation. At this point, I do not know how long that will take, and that means that you will stay where you are until we are able to either arraign you or you are determined to be incompetent.
So I don't have, I'm not, like I said before, I'm not a surety. Yes. I'm not a ward. I'm actually a protected individual, and I did no crime. There has been no body of a crime, no corpus delicti. I have committed no crime at all.
Mr. Magoo. If I cannot determine whether or not you can understand what you're being charged with, then I cannot arraign you.
Okay.
So,
if there is not a body of a crime, if I have not harmed anybody, then you can't arraign me. It's corpus delicti. It can't happen. And if you do try to enter in a plea of competency, or I don't know what is that? What you're gonna hold me here hostage until what? A body of a crime happens? When is the crime gonna happen?
Actually, I'm not even mad.
And that's where we end. No arraignment, no progress, just a one-way ticket to competency evaluation. This case highlights what happens when courtroom drama meets misunderstood legal theory. The defendant may believe he's invoking constitutional wisdom, but without preparation or understanding of due process, even the most confident argument can collapse under pressure. So what's next? A mental competency exam, procedural delays, and maybe, just maybe, a reconsideration of legal counsel. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom
Mr.
breakdowns.
Magoo, we will not be proceeding today with the arraignment. You are free to go to the door and tell the jail that you are finished. Thank you.